Hey everyone, welcome back to today's video where we return to Judge Green's courtroom for part 4 of the Frank Micho case, known as the Consumed Crayons case. In part 1, the matter was first heard before Judge Green, who then referred it to Judge Oakley in part 2, which turned out to be completely unexpected and chaotic. Now in this part, we continue following the unfolding courtroom events and see how the situation develops further in this unusual case. This episode highlights the ongoing legal confusion and courtroom tension as the case moves forward step by step, revealing more unexpected details along the way.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the Black Robe.
In part 3, the case returned to Judge Green's courtroom, continuing the ongoing proceedings from the earlier hearings. After the events that took place before Judge Oakley in part 2, the matter came back for further review, showing more developments in courtroom activity. That brings us to today's episode, where the story continues to unfold step by step, leading into the next stage of the case. So, let's begin and see what happens next in this ongoing situation. Let's continue with the story unfolding ahead.
6FY. This is State of Michigan versus Frank Micho. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Micho. I am a beneficiary of the Frank Anthony Micho estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the duress and coercion.
Thank you, Mr. Micho. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple preliminary matters.
Before we do that, Mr. Micho, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of some things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one, is the jurisdiction that the court is operating upon.
Judge, I'm going to object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm going to object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Micho make his record.
Yes, ma'am. Okay. Constitution, the 6th Amendment grants me the right to know the nature and the cause of the action. I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Oh, yes, the jurisdiction of...
You may continue asking the same question, but the answer will not change. You were found to be a convicted felon in possession of a firearm, and on top of that, you brought that weapon into an airport. This makes the case a criminal matter, not civil or commercial, and not related to admiralty, maritime, or common law. It is strictly a criminal offense under the court's jurisdiction, and no alternative classification applies here. The court will proceed accordingly without exception.
Criminal, civil criminal. And I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So,
Mr. Micho, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.740124 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a Range Rover. Contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time he committed you committed or attempt to commit a felony, to wit, felon in possession of a firearm, contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter, the court's question back to you, sir, is are you prepared to proceed with the exam in this matter?
No, you still haven't.
You can keep repeating the same question, but the answer will remain the same. You already served 30 days for repeatedly ignoring instructions and continuing to ask the same thing after being told not to. Another 30 days could be added as well. In reality, the court may issue multiple sentences, so you will end up with plenty of time to understand what jurisdiction applies in this case and why the ruling stands as it is. The court will continue to proceed based on the facts and prior orders without changing its position.
District Court to you before, sir, and I will renew that indication to you. Are you prepared to proceed with the exam?
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, well, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as a trustee for them.
He is acting as if his lawyer is a trustee, but that idea is clearly incorrect. Despite making many unreasonable and inaccurate claims throughout the case, this suggestion stands out as one of the most confused. Even so, compared to everything else he has argued since the beginning of the case coverage, it is oddly one of the closest things to a sensible statement he has made, though still legally wrong. The court continues to rely on proper legal definitions rather than these misunderstandings.
You're not under any threat. This is a court. You've appeared this afternoon. This case has been called, and if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the court's, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And you, while you're asking me, you also telling me that we're about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So,
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you,
okay,
but I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
Okay, I just want to ask you, far as, hold on one second. I want to read this for you.
No, sir. You had a question. What is your question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party and interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but
Okay.
it says that possession of a deadly weapon is a commercial crime, so I need to have a better understanding if this is a commercial crime. You said this is a crime, and there is no injured party where I hurt anyone. You haven't gave me the right to face my accuser, and it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So I understand that commercial is civil, but you're telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you operate under? Is this civil or criminal? Because it doesn't make sense.
What you're referring to in CFR 2772.11 has nothing to do with a felon in possession of a firearm charge. That section of the Code of Federal Regulations is specifically about property that has been seized and how the ATF handles or disposes of it. Even the definitions in that part only apply within the context of seized property, not criminal firearm possession cases. Your case is about illegal possession by a convicted felon, so that regulation does not apply here at all and cannot be used to challenge the charge.
Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27/7211. All crimes are commercial. So I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threat and duress of coercion, I appoint Sullivan as my trustee for the record.
At this point, I'll just let him continue calling his lawyer a trustee, even though that clearly makes no legal sense. I bet he couldn't even correctly spell lawyer or trustee if asked. So instead of going through all the long, low-quality audio of his so-called attorney questioning the officers, we'll skip ahead to the important part. That brings us straight to the end, where the judge delivers her ruling on whether there was enough probable cause to justify the arrest or not.
Michelle's record and Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion. And it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice. Your previously entered bond with any conditions.
That's the end of today's video. This might be the last update we see on this individual for a while, as the case has now been sent to circuit court, where proceedings are not always open for public viewing. However, If there are any new developments, they will be shared as soon as possible. For now, the situation appears to be moving into a longer legal phase. Thanks for watching. If you enjoyed the video, you can like it, leave a comment, and subscribe with notifications turned on so you don't miss future updates.